You're welcome back to Newsfile. This is your most authoritative news analysis show with me, Samson Ladi Ayenini. And before we get to help all of us to attempt to properly appreciate what the effect of the decision rendered by the special chamber in Germany is concerned, let me now introduce my guests on the show to you. And my guests on the show are regular panelists: Abdul Malik Kukubaku, editor-in-chief of the New Crusading Guide newspaper; Dr. Eric Odro-Osai. He is a lawyer and a governance expert, and thankfully, he's somebody who is read in this area of the law. And so as the delivery was going on, he was assisting some of us to properly appreciate the things that are going on in the Itlos chamber. Also, Mahama Yariga is MP, is a lawyer and MP for Boku Central. And Nana Akumia, Managing Director, State Transport Company, and former Director of Communications to the New Patriotic Party. We're going to the phone lines to speak to a couple of experts who have been following this case very keenly and who have the specialty to be able to share with us some very important lights. Thank you very much, Dr. Theo Echampong, for joining us.
Yes, afternoon, Francis Sampson.
Great, very good to have you. And you had some predictions. For example, you were very clear that Ghana's argument for the use of the equidistance methodology will win the day. You have improving rights, but we are in a hurry. Tell us of the unanimous positions that they make. Number one, that they find that the special chamber has jurisdiction to delimit the maritime boundary between the parties in the territorial sea, in the exclusive economic zone, and on the continental shelf, both within and beyond 200 nautical miles. And with emphasis, 200 nautical miles. You will explain that to us, what that changes in the whole argument as put forward by Ghana and Ivory Coast. Because there was an initial insistence on 100 nautical miles. Now, number two, they say that they unanimously find that there is no tacit agreement, and this was Ghana's decision, Ghana's view, that there was a tacit agreement between the parties to delimit the territorial sea, exclusive economic zone, and continental shelf, both within and beyond 200 nautical miles, and rejects Ghana's claim that Côte d'Ivoire is stopped from objecting to the customary equidistance boundary. Ghana said Côte d'Ivoire, by certain conduct, including local legislation that it had passed, had sort of admitted that this is what has been the situation for over 50 years. So Côte d'Ivoire cannot come today to claim that there is any dispute on this boundary. The court says you are wrong. We object that. Now, they say, number three, that they unanimously decide that the single maritime, and this is the whole effect, the single maritime boundary for the territorial sea, the exclusive economic zone, and the continental shelf within and beyond 200 nautical miles starts at BP 55 plus with the coordinates. And I suspect you may have the benefit of it. You are still in transit, traveling from one country to the other. Did you get the benefit of the coordinates? Do you have them?
Yes. So
great.
Lastly, the court has actually just made the full ruling available online.
Great.
The PDF version, which has them up.
Right. Okay. So let me not proceed further. On that note, what is the effect of the decision as rendered right a while ago?
I mean, thanks once again, and I think it really boils down to us as a country understanding what the new coordinates are and whether or not any of our oil fields are affected. Just by cursory look on what the court has provided in the PDF document on their website, it doesn't look any significantly different from what Ghana was arguing for earlier, using boundary pillar 55 as the baseline point.
Interesting.
So the court is just proceeded to define a new boundary pillar 55 plus, and then on that basis delimited three things. It delimited the territorial sea, which is within the 12 nautical mile zone, and then applied the equidistance method to further delimit the exclusive economic zone, and then the continental shelf, which is, over and beyond 200 nautical miles. But just looking at the map that the court has produced in its judgment, which I just downloaded on its website, the map does not in any way significantly suggest that, our oil fields are going to be materially affected.
You say it does not suggest that our fields will be materially affected. We had provisional...
Yes, I say that because we don't currently, on the map that is available, we've not been able to, they have not put the fields side by side alongside the new boundary. So that's sort of some work that has to be done, taking the coordinates, putting it in, and putting our offshore oil fields to then see whether or not they are affected. But as I look at it now, and given what we have been arguing for historically, it does not suggest to me that our fields are going to be that much affected, if any at all.
Okay. The areas disputed, we are talking about portions of the 10 and the deep water tunnel blocks in Ghana's territorial waters. And we have been exploring commercial oil in these areas, and we're talking about an estimate of 4.5 billion barrels of oil, equivalent to 75%, which lies in Ghana's deep waters. Now, the disputed maritime area is estimated to hold about 2 billion barrels of oil reserves, 1.2 trillion cubic feet of natural gas. Over 60 discoveries have been made in the basin. By this ruling or this decision, which you say it doesn't appear that much of our fields have been affected, do you have a clear sense of what we stand to lose?
Thank you once again. I don't think we really stand to lose much. It's important here to clarify that the court actually rejected Côte d'Ivoire's claim for quote-unquote compensation, based on what Ghana has done historically. So, I think really going forward, we don't really lose much by way of, paying compensation to Côte d'Ivoire. But the current fields that we have, 10 and then the Hess discovery, which in any case were likely to be affected, we need to then plot these new fields given the new maritime boundary and then look at whether or not those fields are affected. If they are, then it means then we would have to cede part of the revenues that we get from these fields to Côte d'Ivoire under some sort of joint development zone or some sort of arrangement. But what I would then argue, if that were the case, would be, depending on how the revenues are shared, if it's 90-10 or 95-5, then Ghana can just pay Côte d'Ivoire on an equity basis and retain the current fiscal regime that we have for the region without the need to renegotiate all these petroleum agreements all over again. So just to summarize, I think that we do not lose much as a country in the sense that there's no compensation payments that we'll have to pay to Côte d'Ivoire. That was flatly rejected by the court. But then when we now plot the new fields against the new maritime boundary and we discover that, a little portion of it, goes into one side, then it raises the question of how we'll then compensate the Ivorians for that. As I sit here, and as I said earlier, I do not really think that that is going to be so much of a problem, because the boundary line that was defined, the new one that was defined by the court, it's more or less in line with what Ghana was claiming earlier.
Doc, we have so far since 2010, when we discovered oil in commercial quantities and started production in 2010. I mean, we have so far earned some $3.5 billion US. We have gotten to a point where, also because of the rollout of the free SHS, we rather anticipate to make more rather than lose even a dime from oil production. You seem to suggest that by the readjustments that have been done, we definitely are not going to have it as we did, right?
No, I'm not suggesting so. What I'm suggesting is we actually need to plot our oil fields against the new adjustment. And two things are likely to come out of that, just to restate. Either we would find little portions of our oil fields, on the other side of the line, or, as I seem to intimate, that we probably wouldn't find any of our current oil fields, namely 10 and Hess, being particularly affected by it, which then means that we would then get to keep these revenues as is for ourselves. And you're right about the bigger point, where we are expecting oil revenues to actually contribute a sizable chunk of the nation's domestic revenue sources. Okay. So currently, as we speak, oil revenues are accounting for about 1.5, 1.6% of our GDP. And back in 2014, it made up 13.5% of our domestic revenue. And it's tied to a number of government programs, including the free SHS. I do not really think that, given the ruling and given the new maritime boundary, that is going to significantly change in terms of our revenue expectations.
All right. Dr. Theo Achampong, he is a petroleum. He has expertise in petroleum and the oil industry. Petroleum economist at the University of Aberdeen. Thank you very much, and wish you a safe trip. I understand that you're heading you're heading here into the country. Thank you very much for your time, Doc.
All right, thank you so much, Francis. Sorry, Samson, and
right.
We can.
But finally, can you say, for example, that on the totality, Ghana has won effectively?
Oh yes, absolutely. I mean, if you look at the totality of the argument, the only point where we really lost was the court, going ahead to dismiss the so-called tacit agreement that did exist. But that is not without precedent. So in the Myanmar and Bangladesh case, the court likewise also dismissed the so-called tacit agreement between those two countries, and then went further ahead to define a new maritime border and use that. That then becomes, the new maritime border for those two countries. And the court has done a similar thing in the Ghana Ivory Coast case. So this is not exactly new in that sense of the word, that there is strong legal jurisprudence on which the court made those claims.
All right. Thank you very much. This has been useful. Thank you very much, Dr. Theo Achampong. He is a petroleum economist with the Aberdeen University. Thank you very much for your time. And as you heard, he's by his analysis, and a good friend of mine, Kofi Bentil, who has also been analyzing all of this from the beginning, when they gave the provisional orders against Ghana, stopping any further exploration activities within the 13 other, wells that were already pending. Imani Ghana issued, they actually did infographics explaining what it meant at the time. He also says, yes, we have won, but of course, there has been some very minor modifications to the way we wanted it. But how minor? How significant for Cote d'Ivoire, really? Doc, thank you very much. And we will be talking to a couple of other experts within this area, particularly those who have been at the forefront of this particular process. You know that Ghana had 10 official negotiations, rounds of negotiations that failed to yield any results. In fact, the special chamber calls it fruitless, needless really, because in the end, we just wasted money and time traveling up and down Cote d'Ivoire and Ghana and elsewhere trying to settle this matter, and it didn't work. If you have heard Honorable Inus Afuseni before, who was the Natural Resources Minister at the time, when we eventually took the decision, as announced by Marita Apia-Opong at a press conference, that we felt the way to go was to go to court to settle this, because at a point there were threats that were beginning to produce symptoms of what could have become a war of sorts within that area. So we'll be speaking to some of those who have been involved. You've heard Professor Mfojo here on this show at the beginning. We're trying to raise some of them to give us their perspectives. Mr. Chachichi Keta and the rest of them, we're doing our best to get them to share their views on this. Yes, Doc, this is also an area that you are familiar with. What is your take on the culminative, the entire decision? What does it mean?
Thank you very much, Samson. I think today should be a very good day for Ghana to some extent because we went to the court to start with, and we went with certain reliefs. And I must say that when I look at the conclusions, everything they concluded unanimously, and to the extent that we were arguing that we should use the equidistance principle.
Right.
And the courts, to some extent, agreed with that.
Yeah, you started to celebrate right
definitely, because
when they said that we are going with that.
The point they've given suggested that, one, Ghana has been a very good candidate in this case. Because Ghana has comported itself so well that even with the provisional measures, Ghana did not violate anything.
Good conduct.
Good conduct. And when I realized that Ghana has conducted itself well in the eyes of the special chamber, I was convinced more that we're going to have our way.
Right.
What the court has done basically is to document what Ghana has insisted on from day one. That's what the court has done.
Aspects.
Aspects, yes. But basically, we would have to also, as they call it, put it on the ground. Because the court has made a determination on the territorial sea, on the exclusive economic zone, and then the continental shelf, which is beyond the 200 nautical miles. These things may be technical. But these were things that Ghana was arguing about. But now they have put it to close.
Okay.
The bit about the single maritime boundary, using the boundary pillar 55, tells us that now they have indicated clearly which areas belongs to Ghana and which areas belongs to Cote d'Ivoire. However, going forward, it is up to Ghana to tease out the meaning of the ruling and then start sensitizing people around that. So for me, it's good for us. We are making very good headway, and I don't see it affecting most of our oil fields in most cases. So it is a very good ruling in my view.
Okay. Try and help us quickly.
Okay.
Try and help us understand what has changed by the adjustments that have been made. The coordinates, as were read out. Initially we understood that there was an intention to look at the economic and continental shelf within and beyond, is it 100 nautical miles or something?
Yes.
And then now we're hearing what they were using was 200, and then the BP 55 plus.
Now, Samson, we need to explain these things to people. Your exclusive economic zone is a maximum of 200 nautical miles beyond sea level.
Okay.
So within that range, it is for you. If you go beyond that, then you've entered the continental shelf.
Okay.
Ghana, you remember, we applied to the CLS for an extension. That extension was granted. So we had that extension.
Okay.
Now, what the chamber said was that, well, there is this exclusive economic zone, but the issue of going into the continental shelf has come into play. So let us then make a determination on that. So they made the determination to fall within the 200 nautical miles and even beyond. Now, what this point means is that they have now fixed the boundaries. Previously, the boundaries were not fixed. But now, they have now fixed the boundary to the extent that if you draw the straight line, A, B, C, D, E, F, they have defined the coordinates. So for instance, from point A, you have a coordinate of 0.5 to the north to 0.3 to the west. So you put it there, and you can easily know which area belongs to Ghana, which area belongs to Cote d'Ivoire. And that is exactly what Ghana needed. Because under international law, if you go through the entire process, you will realize that for a dispute to be finally resolved, you have to start from somewhere and end somewhere. You have to start with negotiations, which Ghana started. You do inquiry, you do mediation, you do conciliation, you do arbitration, and we realized that we're not making any headway. So when the issue started coming up and people started talking about it, Cote d'Ivoire made the moves. We thought that we should go. And thankfully, today, they have defined the coordinates made up of A, B, C, D, E, F, starting from boundary pillar 55 plus. It has not significantly modified what already existed on the ground.
Okay. There are no questions of appeal in this matter? That
There are
Cote
no
d'Ivoire may
questions.
not be happy?
No. When you look at Article 33, I was looking at Article 33 of the UNCLOS, that's the United Nations Convention on the Law of the Sea. It is clear that once the court makes its ruling, it's under finality and binding force of the decisions. The decision of the tribunal is final and shall be complied with by all the parties to the dispute. The best a party can do is under Article 33(3), which says that in the event that a party needs further clarity, you
can only go for
you
clarification.
can go to the tribunal, and the tribunal shall construe its ruling as per the request.
Okay.
So there is no provision
Right.
for appeal under Article 33 of the UNCLOS.
But you'll admit, and I go to Mahama Yarga now, you'll admit that when we got to the point where the president said words to the effect that for Ghana to equate the oil fields, or how to, delimit the oil fields to maritime boundary, will be tantamount to penalizing the state for exercising cautionary prudence. Because Ivory Coast, the case was that the fact that we had not insisted on certain things was because we're just exercising, as the court said, cautionary prudence, so that we can be in good neighborliness with one another. So you can't come and say, because we have never raised an objection, now we are raising an objection, we should be stopped. And all of us felt that was a bit...
But Samson, let me add this thing to you before you go to Honorable Ayarika. You see, in the special chambers ruling, they mention it in passing that a distinction between oil commission limits and maritime boundaries are very important. It's very important in this matter. And they went ahead to show the distinction.
Yeah, we didn't seem to have focused on that distinction.
That is
okay.
So
yes,
they focused on
let's
that.
hear from Mama. What do you have to say?
Well, I mean, we all listened to
you were doing the calculations as we were.
the ruling of the tribunal. And I think essentially what the tribunal said is that there was no prior delimitation of the maritime boundaries between Ghana and La Cote d'Ivoire. The argument of Ghana was that there was some effort, and tacitly Ghana's position was that there was an understanding regarding the
by conduct, particularly
the boundaries between the two. But the court dismissed that. But then the two countries proposed two different approaches for determining the boundary.
Equidistance by sector.
The tribunal rejected the Ivorian approach and accepted the Ghanaian approach.
Because that's the precedence, and that is internationally accepted.
Yes, modified it. And then they calculated and set the coordinates. I have a technical team sitting somewhere made up of, former ministers of the NDC regime who really were involved in this. And by their calculation, we have actually gained territory.
We have gained territory?
We have gained territory. That's the argument. Oh. And they just called me to indicate
That's good news.
We've actually gained territory.
How much?
They haven't indicated exactly how much.
They have to match the new coordinates.
So they're actually doing that. Whilst the tribunal was ruling and fixing the coordinates, they were also determining the coordinates based on their earlier projection of how, if their calculation of the equidistant principle had been applied, where we would be. But then with the modification that the court has made, they tell me that we have actually gained some territory. And so Ghana hasn't lost anything. Ghana really has everything to gain by this particular ruling. So I think that, like you said, it's for people on the ground to go and apply the coordinates. And those technical people are telling me that we are gaining territory by this process.
Okay, and there are people who have been at the front of this or very close to the process, or Ghanaian team as the process was going on, good friends and colleague lawyers, and from the information they are sending to me, including that all our concessions are protected. So it's not a small win if we want to understand it. Right, so we're getting to call a number of them. Now some of them are suggesting they are available to speak. Initially, the team has had a very hectic time trying to raise some of them on the phone. Some of them are suggesting they are ready to speak. So we are arranging to get them to speak to us. And Professor Mfojo, if you're listening, we are calling you. All right, yes, Goku. And you were so disturbed, particularly when it started with, we reject this. Ghana, I said this, rejected. Ghana, I said this, dismissed.
Yeah, to be honest with you, the explanations and, if you like, demystifications that have been offered by Dr. Eric Oduro Osai, am I right?
Right.
And Dr.
Theo
Champon have relaxed me a bit, because otherwise it all sounded like Chinese. I have to be honest with you, I really didn't understand, you know, what was being said. It was a bit complex for me, and I still would really need more information and education. Yes, but assurance, we haven't lost, we've won.
Okay.
For me, as a nationalist, as a patriot, I'm damn happy. But there's one significant thing, and I think I would want to emphasize is, I see a continuity in terms of the defense that we mounted as a nation. You know, the former Attorney General still on board, collaborating and cooperating with the
Okay, Kuku, let me try and get you a lot more you know, understanding,
sure,
so that we can make our joy complete.
Sure.
And joining me, us on the phone, very rare. Don't remember when last I heard that he spoke to any media. This is a lawyer and a former director of the Ghana School of Law, Mr. George Sapon. Thank you very much, Mr. George Sapon, for joining us on Newsfile.
Thank you, Samson.
Help us demystify what has just happened. Ghana has won. How significantly?
Basically, the court appears in this case to have adopted our position on the equidistance rule, which has been consistent with the jurisprudence in these maritime cases since, I believe, the first decision in the Gulf of Maine case in the early 80s. Of course, the Côte d'Ivoire's position was, as we all know, rejected. What we must wait now for us to ascertain on the ground the implications of this, when, let me use the ordinary expression, actual plotting of the decision is expected. But since we went on the tangent of the equidistance rule, my layman assessment at this stage is that we're not going to lose much.
Okay. We are not going to lose anything at all, or we are not going to lose much?
If we will lose, I don't think we will lose much.
This is your area of comfort, law of the sea. By the adoption of Ghana's equidistance, you know, methodology for the measurements, so to speak, and by the rejection of Côte d'Ivoire's, was it not expected from that point that we win everything and Côte d'Ivoire loses everything?
If you listen to the panel, they did not dwell solely on the equidistance. They looked at the special circumstances aspect of the matter.
Right. Which is also an argument Ghana made.
I think, yeah, there could be a plus or minus, you know, in the matter.
Okay.
And that must await the actual plotting, official plotting of the decision on the ground.
All right. Nonetheless, you would say that it's okay for Ghana to celebrate?
Oh, sure. I'm already celebrating.
Okay, thank you so very much. We won't take any more of your time, and we'll take the caution that you gave that we need to await, a further, examination of the plotting as has been done to be clear beyond doubt about what Ghana has gained or lost. Thank you very much, Mr. George Sapong. Mr. George Sapong is in legal practice, and he was the director of the Ghana School of Law. And Mahama Yarga says he lectured him, and Dr. Drosai says he lectured him. Okay, he took me through a few of conference, as it were, engagements whilst he was the director, and I was also at the school. Thank you very much, Mr. George Sapong, for this. He listens and watches Newsfile. He's in good company with those who watch this with a lot of commitment. Thank you very much, and for the guidance you continue to give me whilst I sit here. Okay, so Kweku, you continue. You continue whilst we speak to the others to get you into a more jubilant mood.
Yes, that's though there was a certain caution. That was had a potential of disturbing me slightly, but overall, I believe the direction is clear. And as I was saying, the continuity element in terms of our defense, I think is also beautiful.
Okay.
It's just a signal that there are certain things we can do together in spite of our political differences when it comes to the national interest. But I'm still willing to get better briefing and education because it's still a bit complex for me, I have to be honest. Yeah.
Okay, thank you. Nana, what do you also say? I recall you showing me the trend on Facebook, particularly when our good friend Pakusi Asare, who is now in London, right? Well, somewhere in the Great Britain, and he also was worried, like many people said, you have rejected everything else, so what is going on?
Well, many Ghanaians surely will be quite happy that the general consensus seems to be that Ghana has won. According to my good friend Ayariga, we've even gained a bit more territory than we had before. The learned gentleman you spoke to said even if there was going to be any loss at all, it was going to be very, very slight. So what it means is that a lot of the oil exploration that is going on will be retained. That this whole dispute has arisen because that area has been discovered to be rich in oil. And so this matter has a lot of economic potential for the two countries, Ghana and Cote d'Ivoire. Otherwise, if it was just some expanse of sea with only fish, I don't think the two countries would have been engaged in this long struggle. But there's a lot of oil there. Indeed, there are another 12 or 13 wells that Tallow, the company engaging,
13 of them that they
had to suspend because of this
provisional measures.
Yes. So presumably now all those 13 wells can be explored, and what it means is that a lot more reserves may come on stream, and it will just inure to the benefits of this country. What we're going to have on our hands is a second phase of oil discovery and a second opportunity to leverage oil possession for our economic development. So all of us should be happy. Of course, we should also...
And you must be particularly excited. The president, speaking to Bloomberg this week, was optimistic, and I could see in his face, in his eyes, that if we lost this would be bad news for him because he's looking to leverage on the oil proceeds to sustain the free SHS.
And a lot more. But let's also spare thought for Cote d'Ivoire. I mean, this also, because of the economics of the matter, it represents some huge loss to them. Fortunately, it seems to be a lot of good chemistry between the president of Cote d'Ivoire and the president of Ghana. And I'm sure between them, they will find a way of ensuring that this ruling does not develop into lasting hard feelings between the two countries, because it's essential that we continue to have good relationship with Cote d'Ivoire. For me, going forward, beyond this Cote d'Ivoire-Ghanaian border, Let's look at...
Okay, let's do this quickly, and then we can retire to the studio to continue with our discussions. Also on the phone lines is Godwin Jokoto. He's a lecturer at the Ghana School of Law and a member of the Ghana team to the ITLOS. Am I right, Godwin?
Yes, you are. That's correct, yes.
Great to have you. Now, I can see the excitement in your voice. I hear it.
Yes, I'm really excited. That's correct, yes. Yes, I am really excited.
Okay, so you had indicated to me earlier, right after the judgment, that the understanding is that all our fields are protected. Beyond that, what does that mean?
What it means is that essentially our concession in that area, the 10, that's the Chinugwa and Tunisia, is essentially saved. And that was our major concern.
Right.
Because Jubilee was not really part of the matter or the contention. It really had to do with 10. So once all our concessions in 10 are saved, that's our greatest delight for now.
Great. As a member of the team, I admit that you may be a member of the team, but this is very little to do with law. And even though this is also your area, in addition to the fact that you're a lawyer by training, do you have a clearer understanding of the adjustments that have been made as regards the boundaries?
Now, what I can tell you for now is that some preliminary drawings or plottings of the new coordinates have been done. And it almost tallies with what we have already called the customer acquisition.
Okay.
That plotting is yet to come out. From what I understand from the cartographers and the team in Hamburg, the position is very clear that at least all our concessions are safe.
You could hear from the president throughout the ruling that there was emphasis on the word equity.
Yeah.
In the end, what does Ivory Coast get?
Well,
in the name of equity.
Ivory Coast in this part, or Côte d'Ivoire, gains a lot in this process because, for one, it brings clarity on where our lines will end and where theirs will start. So, at least going forward, when they have to give concessions to their concessionaires, they can speak with some specificity and an attitude to say that this is where the line starts from, so that they don't have to be in a state of limbo as to what we are giving you in the future. There could be any claim on it. So for that, I think Côte d'Ivoire has gained. And the various arguments they've made have indeed been responded to, and particularly their claim on the fact that there was no tacit agreement and they were not stopped. Of course, these 2 points, the court agreed with them and disagreed fast. Right.
What do we do after the judgment today? Are there any things that we are supposed to do before we can officially, as it were, take over, not really take over, resume what we were doing?
Well, for now, we'll take, the judgment is just out. Now, the next point is for the cartographers to draw the lines or the plot coordinates. Now, immediately after that, the parties may speak if there are other outstanding issues, which I do not see any immediately. In relation to the two parties involved. I don't really see any immediately. So first of all, take a copy of the judgment. Secondly, plot the coordinates. And once we are saved, unless there is a gray area which the parties may take up at the high political level to talk about. Otherwise, we are safe.
All right. Thank you very much for your time.
Because bear in mind, let me just say that this law has not got an enforcement arm.
Okay.
Okay, so what you find is that the parties will implement, if they have any misunderstanding, they can go back for clarity, and that's all that can happen. But for now, it's very clear in my mind what the court is out to do by the unanimous judge.
Thank you very much. Godwin Jokoto he teaches at the Ghana School of Law, and he's also a member of Ghana's team to the ITLOS as far as this matter is concerned. Now, yes, there is more assurance, sufficient clarity now. And Nana, you were speaking when I cut you.
I was going to conclude that with this Ghanaian Côte d'Ivoire border seem to be settled, we should take a cue. There's also another border to the east. That's the Ghana-Togo border. Let's not wait, and we know this oil especially runs through the sea right through West Africa. Let's not wait until exploration goes on, money is sunk in exploration in the Keita Basin and all those places, and some discovery is made after a lot of money has been sunk, and then Togo comes and says that there's a dispute, I'm going to court. So let's take a cue and take steps to settle the boundary, the sea boundary between Ghana and Togo, so that we avoid this kind of situation.
Right. Thank you very much, Nana Kumia. And well, as you know now, well, information is just coming in thick and fast, particularly from people who are connected and close to this process, seeking to help us with further understanding. But I suppose that we can end it here, and then the discussions will continue in the course of the week. But the most important point is that Ghana has won, and significantly, as we understand, nothing really lost. But as Mr. George Sapon cautions, we may have to just take it easy and wait. And like Godwin Jokoto said, wait and have the geographers do all the plotting. And Dr. Odrosai also emphasized that do the plotting, and then we can eventually state what it is. I'm sure that the Ghana team will issue a statement, and Ivory Coast will also issue a statement. If there are any issues of lack of clarity, then, as Dr. Drew emphasized, by reading the ITLO's own UNCLOS Article 33, there's no, as it were, there's no room for appeal. You can only go for a clarification of the judgment if you don't understand. But as it appears, there's nothing that ought to be clarified. Well, so interesting there. You want to make some small point again before we move on to the next issue?
I think the most important thing is to also commend the legal team.
Right.
From the Ghanaian side.
Yes, they've done a good job.
They've done a wonderful job, and as a nation, we must recognize the effort that they put into winning this case for us.
The legal team, beginning from those who commenced it, and after those who commenced it, there's been slight changes. Some others too have come in.
One unique example of a bipartisan approach to resolving national issues, or taking a position on national issues. It started with Attorney General Marietta under the NDC, and then the present Attorney General continued with her team, and they've worked together.
It was a beautiful sight when the two of them together went to ITLOS to sit together and to work together before the handing over took place. Ghanaians were very excited about that.
Absolutely.
If the politicians can all, work in this direction, I guess that will not be where we are today.
We can. That's an example of us working together. So why do you think we cannot? This is an example that we've worked together and we have produced good results. And we've been working together on many issues. Very often there are a few cases of disagreements, which, of course, media likes disagreement and friction, and so when there's contestation, not fiction, not friction, not fiction.
Okay.
So we do work together in many cases. So let's commend them for this. But also, like he said, Ghana has demonstrated maturity throughout this process. We have demonstrated good neighborliness with our neighbors, La Côte d'Ivoire, and as he indicated, we must be magnanimous in celebrating our victory. We do appreciate that they also lose something in this process. Truth is that they never invested much in it anyway. We invested so much, and when it became money, they suddenly got interested. But nevertheless, that is legitimate. And also, this has given us an opportunity to settle the maritime boundaries between us and La Côte d'Ivoire forever. I don't foresee any other dispute coming up some other day. And so it is good for us as a country that we have this boundary resolved. And as he indicated, we need to look at the east and also make sure that our boundary with our eastern neighbor is also properly resolved, so that in future, if we find some more hydrocarbons on that side, there is no dispute regarding exactly where it sits.
Okay. And it's a long list of the team. I didn't actually know that there were so many people that were involved in all of it, except the five or so people that you have seen leading the process. And I'm looking at the list here, and because of what Mama Yaga said, I felt like reading out those who were involved.
I think so.
It's a long one.
No,
starting with
it's worth it.
Okay. So
we're about to begin a debate on Founders Day.
Let me try because as announced, our team, the Ghanaian team, the Republic of Ghana was represented by Her Excellency Miss Gloria Efua Akufu, Attorney General and Minister for Justice, as the agent. Also, Miss Helen Ziu, Solicitor General, as the co-agent, and Mr. Daniel Alexander QC, that address is being provided. Miss Marita Brew Apia Opong, former Attorney General. Miss Clara E. Brellingber, okay, who is in the States, United States. Mr. Pierre Klein, Professor. Oh, he's a professor. And then we had Miss Alison MacDonald, Mr. Paul S. Richler. We had Mr. Philip Sands, Miss Anjali Singh. We had Mr. Fui S. Chikata. They were as counsel and advocates. Okay, counsel and advocates. And then we had Miss Jane Aheto. We had Miss Pearl Akiwomi, those from the various ministries who were assisting. Mr. Anthony Akoto Ampao. Mr. Godwin Jokoto, we just spoke to him, Faculty of Law, University of Ghana, Accra. Miss Vivienne Gajepo, Minister of Petroleum. Mr. H. Kwesi Prempe, okay, so you know him, he's been on the show. And presently, he's also assisting demystify the judgment on social media. He says social media is one home where he sits. Also, Mr. Nicholas M. Rainsler, Miss Alejandra Torre, and as counsel, we had Mr. Kwame Infojo, who was on the show here earlier when it started, and we were trying to actually get him on the phone as well. He's Maritime Boundaries Secretariat, that's where he is. Miss Azara Prempe, Miss Adjoa Riafe, legal advisors, Miss Penina Asadankwa, Mr. Samuel Adote Anum, Mr. Michael Nyaba Asibi, Mr. KK Sapong, as advisors, Mr. Ni Ajay Akko, Mr. Theo Eshrain, Mr. Lawrence Apalase, Mr. Aya Ama, Mr. Michael Aite, Mr. Nana Boache Asafoeje, Mr. Joseph Asenso, Mr. Robin Cleverly, okay, Mr. Scott Edmonds, Miss Vicky Taylor, Mr. Nut Hartman, Mr. Daniel Kranting, Mr. Thomas Menu, Mr. Kwame Into Amwa, Mr. Nanapoku, Mr. Sam Toppin, and finally, as technical advisors, Miss Elizabeth Glossman, Miss Noyelis Iroko, Miss Nancy Lopez, Miss Leah Main Klinks, forgive me if I'm just not getting your name too correctly, and Miss Lara Sons, and that's it. And then the Ivory Coast team also follows. Who is that?
The person whose vision it was to use this medium to resolve the dispute.
You mean the minister?
The ex-president, Jerry John.
I thought you were referring to
Dramani Mahama.
Inusa Idrisu.
No, it was the president's decision.
Okay.
So the decision of President Mahama.
I think that's fair. I think that's fair. That's fair. We take a break here. Right. So that's fair.
He couldn't allow this to pass.
No, but that's the reality. If we acknowledge the contributions, then the person whose vision it was that look,
But it will be the decision. It will be the decision of the Attorney General, Marita Briu-Appeal-Pong.
No, it will be the advice.
Okay.
The Attorney General. But
well, I think.
Okay, thank you very much.